Hello students, this is your faculty Dr. Zubair Ahmad, Assistant Professor, BBD University. Today we will discuss the topic Nature of Contract, Offer and Acceptance in Business Law, Code BBA 3303. To avoid any type of fraud, malpractices or cheating, Indian Contract Act came into existence in 1872, and at the time of formation, Contract Act was very large. So in 1930, Sale of Goods Act, and in 1932 Partnership Act separated from Indian Contract Act. In Indian Contract Act, there are two terms. One is agreement and the other is contract. So if an agreement is of domestic or social nature, it is not transformed into a contract. But if an agreement is of commercial nature, then it can transform into a contract. For example, if A wish to sell his car to B and B wish to purchase his car, then this agreement is of commercial nature and it can transform into a contract. And contract is enforceable by law. How we can find the nature of contract? We can say contract is a promise or it is a legal binding. There are two persons, one is the promiser and the other is promisee. Promiser offer a work to the promisee and the promisee accept the work against its offer. So if any person, the promiser or the promisee, cannot perform his obligations of the contract, then the other party, we can say the aggrieved party, can sue him or her by the court. Essential prerequisite of a contract. So what are the essential prerequisites of a contract? Number one is presence of two parties. So for a contract, there will be two parties. One offer the work in a contract to the other party and the other party gives his or her acceptance to that work. Then the other prerequisite of a contract is agreement. Agreement should be of a commercial nature. For example, if A wish to sell his car to B and B also wishes to purchase the car from A, then it becomes a contract. Now comes the consent. So there should be a free consent from both the parties. Free consent means there should be not any force or influence on both the parties. Then comes legal relationship. Legal relationship means that the contract is of a good nature, or we can say it is under the legal laws, means we cannot do the contract for an illegal purpose. Then other prerequisite of contract is contractual capacity. So the person who wishes to make a contract is of a sound mind and his or her age is about 18 years. So he can uh, do a contract from the other party. Then the last prerequisite of a contract is we have to avoid any unlawful conspiration. It means that we can do a contract under the law or which is applicable or permitted by the law. Offer. So in a law of contract against promissory performance, we can offer money or other valuable thing from a promisor side. Offer or a proposal is a starting point. Proposal is by one party and it is a form to enter into a contract from the other party. Promise or set of promises makes an agreement, and promise we can say it is a result of a proposal made by one party and it is accepted by the other party. So we can say offer is a type of proposal made by one party and accepted by the other party. Acceptance. So in Indian Contract Act, acceptance means that the yes of the other party to the proposal of the first party, and it may signifies the assent to the offer, and it is said to be accepted. And the proposal, when it is accepted, it becomes a promise. For example, A offers to buy B's car for rupees 2 lakhs and B accepts such an offer. Now this has become a promise. And an offer can be revoked before it is accepted. But if it once accepted and communicated, it cannot be revoked or withdrawn. This is a condition in acceptance case. So that's all in today's my lecture. Thank you.